Yes, thank you. With us on Fiji Village Trade Talk, I'm Vijay Narayan, a special show this evening for you as we reached out to the Commissioner of the Commission of Inquiry, looking into the appointment of Barbara Mali as FICAC Commissioner, Justice David Ashton-Lewis, who's joining us via Zoom after we reached out to him. Justice Ashton-Lewis, thank you very much for accepting our invitation to come on this show to clarify certain issues regarding the COI and what has been said.
Well, thank you for inviting me, and I'm happy to do so, Mr. Narayan.
Justice Ashton-Lewis, just straight into it, we had spoken to the president of the Fiji Law Society, Wylie Clarke, and he has made some comments. Of course, as you know, in the recent High Court ruling, a number of decisions were made, and we will touch on a few of those. But while we were talking to him in an interview that aired yesterday, he also talked about his first meet and greet meeting with you before the COI, and he said there was some inappropriate conversations where you first kept saying to him, what would the Law Society feel about having an expatriate Chief Justice? And then later you said to him that you should be the Chief Justice of Fiji. Did you say that?
No, I did not. My recollection of what Mr. Clarke is saying is completely different. I have no recollection of any conversations with him other than in the meet and greet, because he was going to do an affidavit and would probably be called as a witness. Now, the way the Commission of Inquiry operates is you decide, usually counsel assisting the commission and the commissioner decide who should give evidence dealing with the question to be determined. So Mrs. Mason, a barrister from New Zealand, she was the counsel assisting. She formed a list of 32 people who should be asked to swear an affidavit and give evidence. And I went through it and I was happy with that. Now, then when you've got all the affidavits in and you have, during the collection of the affidavits, with each deponent, you have what is called, or we did, and I set the procedure as under the Fiji Commission of Inquiry Act, 1942, I set the procedure. So that Mrs. Mason set up a meet and greet meeting with all the people who'd given an affidavit and who would most likely be called to give oral evidence. Now, Mr. Clarke was one of those, and we had a meet and greet session with him where Mrs. Mason outlined the Commission of Inquiry, what the terms of reference were, what the scope of the inquiry was, and what the main reason for the Commission of Inquiry, and then would go through any evidence that particular person would be asked to give. Now, that's the only recollection at this time of any conversation that I had with Mr. Clarke. And the language he uses, that he said he felt uncomfortable and I was pushing him, that's just not true. I don't behave like that. And no conversation about me being the Chief Justice was brought up. But I can tell you of a meeting in 2023 at, what is the name of, I don't want to mispronounce it, Ashani, is it? Indian restaurant in Victoria Parade.
Ashiana restaurant.
Ashiana in Victoria Parade with...
What happened there?
With Hemendran again. In 2021, when he was still the leader of the opposition, the Prime Minister asked me, because I'd been a judge in the 90s there, and I'd been constantly going back and forth giving lectures on company law, constitutional law.
Justice Ashton-Lewis, with due respect, let's stick to the Clarke meeting first, and we'll talk about this other meeting so that there's clarity for people who are watching. in relation to the Clarke meeting, so that people do
Yes.
not get confused, Wylie
Yes.
Clarke has said he was utterly shocked, and the others in the room were also shocked. He talked about
I'm aware of what
Janet
Mr.
Mason.
Clarke has said. I'm
Janet
aware of
Mason.
that.
It's
And
it's for people.
I'll
It's for
ask you.
people. It's for people to know what he
Yes,
said,
I
as this is
understand.
being viewed by people. Justice
Yeah, well,
Ashton-Lewis.
you will no
So
doubt get that out.
now Clarke said he also said he told you that this is a really inappropriate conversation, as the Law Society has no role to play in the appointment of the Chief Justice, and it was inappropriate to discuss about you becoming the Chief Justice, because the COI, in its terms of reference, was supposed to deal with the Judicial Services Commission, and the chairman of the JSC is the Chief Justice Saleh Sikep. Can you tell us, was there any discussion at all about it?
No, there was not. That's about as simple as I can put it. And I can, but I won't do it now, as you have requested. I'll wait till you ask. But the answer to what he states is no, it did not take place.
Okay, but you are now saying, let's go to that Asiana restaurant conversation.
Yep.
Now you are talking about you had a conversation with Wylie Clarke and Hamed Nagin, the lawyer?
Yes. I was.
And you were
having
dining there?
Yes, we were having a dinner, and it was after, that's back in December 2023, and it was after the Commission of Inquiry into then Chief Justice Kamal Kumar had passed away. And so we were having dinner, and we talked about the state of the law, the bar, the bench in Fiji, and that's where a conversation came up.
What was the conversation about?
Well, the conversation was I had been approached in 2021 and asked by the then leader of the People's Alliance, the opposition, would I accept the office of Chief Justice? Because again, I remind you, I was acquainted with Melanesian, Indo-Fijian, Fijian society because I had been in the Pacific for 35 years at that stage. Anyway, I was asked, would I be interested? My reply to then a leader of the opposition was, let's wait and see if you become the Prime Minister and then ask me. Well, he did become the Prime Minister in December of 2022, and it was raised again with me. And I said, well, when I'm requested formally, I'll give you my answer. But I would be happy, and he said, because we need to reform the bench, we need to reform the bar in Fiji. And you, I believe, he said, would be good at that. And I said, well, then I would give serious consideration to it. I've been a judge here in the past, and that's where it was left. When I was dining at Asiana with Hemendra Nagin and Wylie Clarke, this conversation about the state of the law, of the bench, of the bar came up, because both of those men are barristers in Fiji, and they appear. And so it came up, and I mentioned to both Mr. Nagin and Wylie Clarke the conversation that I'd had, or that the Prime Minister then had asked me prior to becoming the Prime Minister. At that stage, he was the Prime Minister, and no such question came up again, except that a few days later, I was sworn in at his request as a judge of the Supreme Court. I wasn't the Chief Justice. I was sworn in as a judge. And at that stage, Justice Timo, or Chief Justice Timo, was the acting Chief Justice. So I was sworn in for a period of 3 years in December 2023 to the Supreme Court. And so at that meeting, I distinctly remember Mr. Clarke stating, look, if you're offered it, please take it, because we really need reform. Now, him mentioning about the role of the Law Society, yes, he was right. The Law Society has no role in who appoints the Chief Justice, but the Law Society, as the major if you like, body of the lawyers in Fiji will always be asked, the president will always be asked, what is your view and what is the legal profession's view of someone being appointed? Now, at that stage, I don't think he'd ever been approached. What it was a conversation between myself, Wylie Clarke, and Hemendra Nagin about the state of the bar, the state of the bench. And I distinctly remember Mr. Clarke saying, oh, golly, we need renewal in this. So if you are offered it, sir, please accept.
Ashton-Lewis, Ashton-Lewis, now you have said that there were at least 2 conversations with Mr. Ramuka as firstly as the leader of opposition, and then again when he became the prime minister. Just with that in mind, and then you coming in and becoming the commissioner that is looking into the COI, and which includes in relation to decisions made by JSC, which is chaired by the current Chief Justice Salesi Temo. And with some of these conversations happening, don't you think it's a conflict of interest? Because knowing that there's some things at play on whether you should become the Chief Justice?
I made no comment in 2023. Remember, the COI came about at the end of 2024. The conversation that I have just recounted to you took place a year before. I made no comment about the then acting Chief Justice. I just relayed to these men what the Prime Minister had said to me. It was them who said, oh, please take it if you're offered it. They made no embarrassing comment about the current the then acting Chief Justice. No comment was made about Salesi Temo. And the Commission of Inquiry came out a year later, was put into place too, and you've no doubt read the information about it, to Mrs. Mason and I to identify the crocodiles in the pond.
To look at crocodiles in the pond, what does that actually mean? I mean, for you, is it a fishing expedition or?
A commission.
It seemed like a fishing expedition.
Well, hold on. Do you know, I said to you before, a commission of inquiry is by its very nature an investigative, and if you want to use crude language, a fishing expedition, so that evidence can be handed to, in this case, the Prime Minister, and then it's up to the Prime Minister to decide what to do. Either give it to the Office of the Director of Public Prosecutions or give it to the police. So in one way, yes, you could say that a commission of inquiry is an exposition into, is there any evidence? Now, the term crocodiles in the pond was used by the Prime Minister. That is what he asked Janet Mason and I. Will you please identify the crocodiles in the pond? When we met with him before the actual commission got underway. And I think, and he just expressed that he believed that there were people seeking to undermine his role as Prime Minister and the government. And so that's why he commissioned a commission of inquiry to look into that and either find, no, you're mistaken, there are no crocodiles in the pond. It was his words he used of those people. Well, he didn't name anyone at that stage. He just said, there's attempts to undermine my prime ministership. Will you please identify, and his words, the crocodiles in the pond? And that was the task that Mrs. Mason and I had.
Justice Ashton-Lewis, I mean, it's not legally written that you have to go and identify crocodiles in a pond.
Oh, but look,
it was a commission of inquiry into the appointment of the FICAC commissioner.
Yes. So that's what it was about.
What about these crocodiles in the pond?
Are you going to let me?
No, I'm just trying to understand it because you brought that up.
Well, let me explain to you, because you're not a
Go ahead.
lawyer. And so therefore, to deal with, you see, it was the Mali matter that had led him to believe that there were people acting against him. And his view was that Barbara Mali was unfit to hold the position of Commissioner of FICAC. So, like anyone, he had a view that Barbara Mali was not fit to hold the position. Would we look into that? And two, would we look into the question of people supporting her and putting her up? Because and I don't know what he knew, he didn't tell me then, but he'd obviously come to the view that there were other people who were seeking to get rid of him, were pushing Mali because why? Because there was a feeling of he and others that Miss Mali would dismiss and close down cases against people who he saw as crocodiles in the pond, one of them being Manoa Kamakamitha, then Deputy Prime Minister. And he saw that he was pushing probably to overthrow him. Now, we had evidence in the Commission of Inquiry, and I won't name them because it's all out there. We had evidence of certain conversations that were made between certain people, and you will know the named people who'd made comment that was inappropriate, and that acted to discredit the government and the Prime Minister. And so the whole basis of the Commission of Inquiry was to look into the appointment of Barbara Mali and who supported her, who put her up for it, and would you look into her background, her qualifications? Was she appropriate? Or was she just the spearhead of a group of people who wanted to get rid of Sitiveni Rabuka and the government? Now, I can't be clearer than that. Is that clear to you, Mr. Narayan?
Yep. Justice Ashton-Lewis, just asking again, because you started off, why I'm asking you about crocodiles in the pond, because you said first Mr. Rabuka did not mention anyone, but then you have said about Manoa Kamikamitha. Did Mr. Rabuka mention that?
I understand. I said to you, Rabuka used a general term, a pejorative term, crocodiles in the pond. As we started the investigations, getting evidence, we got evidence of certain people emerging. One of those persons was Manoa Kamikamitha. We had evidence before us of statements made by the Deputy Prime Minister about Barbara Mali that she should do her position because she will handle and wind up prosecutions against key people. And so Rabuka's thing was, I think there are these things going on, I need to know. And that's what the Commission of Inquiry was set out. So it was to set out the appointment of Barbara Mali. How did it all come about? Why did the JSC support it? What comments were made by certain people, attorneys general, solicitor general, in supporting Barbara Mali? Can you find, well, I should step back. One, did they support Barbara Mali being appointed? And if they did, why? Now, again, I'm not going to go and name people. They're named in the report, but there were a number, three senior government people and about 4 senior lawyers and some senior public servants who, as Mrs. Mason got affidavits from them, came out. They seem to all be involved in the supporting of Barbara Mali to be appointed. So it was the Commission's job to investigate that. And the Commission did. And have you read the Commission of Inquiry report, Mr. Narayan?
Yes, I have.
Well, you will be aware that it made recommendations of of 9 people, including Wylie, that they be investigated. Wylie to be investigated. Well, the Prime Minister dismissed her, had the President dismiss her. Now, I won't go in other than say I had one minister come in, give evidence under oath about comments made by the then Deputy Prime Minister about the matter that he was being investigated by FICAC for. When that comment of that minister was put to Mr. Kamakamitha, he said he never made it. No, it was a lie. So when because of conflict in some areas, we recalled some witnesses, and this other minister recalled, and Mrs. Mason was quite strong on him in cross-examination. You said A, Mr. Kamakamitha denied it, and he said B. Both of you can't be telling the truth. So what is the truth? And Mrs. Mason then put to that minister the conversation again. Did the Deputy Prime Minister make that conversation with you? And that minister said, yes, he did. Now, then I had to make a decision, who do I believe on the balance of probabilities? Because when you get, as you probably know, Mr. Narayan, in law, when you get what is known as he said, you said, a judge has to, or counsel have to really examine clearly, and then it's up to a judge to make a decision. Well, I made a decision, particularly in the Deputy Prime Minister's case, that he was not telling the truth under oath. That is called perjury. Now, so
I'll stop you there, Justice Ashton-Lewis. Yeah. Again, we need people to understand. If not, it'll be a very long story where people can't get things connected. The High Court has thrown out that case regarding Manoa Kamikamitha due to insufficient evidence. What do you have to say about that?
Well, I can say I don't agree with it. Had I been back on the High Court and had the evidence that I received in the Commission of Inquiry, I would have upheld a finding against him. But I can't speak for what another judge will find. I can say, well, that judge found that what he had was no case to answer. Now, no case to answer means there wasn't sufficient evidence. So obviously that judge believed the Deputy Prime Minister's version. I chose not to believe that. I believe the accuser's version. But that doesn't.
I'll go with the courts, because the courts decide, and you being a former judge of our courts.
Yes.
We respect our courts. It's the rule of law. If the court decides based on what is presented, based on all the evidence, that there's no case to answer, Justice Ashton-Lewis, that we should respect that ruling.
Well, I do. I do respect it, but I think I need to remind you, my findings were not, so my view that he was not being truthful was not as a judge in the High Court, and it was not adjudicative. It was as a commissioner on a commission, let me finish, a commissioner of inquiry who has to make a finding and then present his findings to the Prime Minister for the appropriate steps to be taken.
And the following, the Prime Minister would then
I haven't finished, Mr. Narayan. I let you speak. Please let me finish. I agree with you. I respect the rule of law. I was a judge in Fiji, and I have a great love for it. So what my answer to you is that another judge heard evidence and chose one way. I heard evidence not as a judge, but as an investigating commissioner. And I chose to make a finding another way. But you're right when you say that this is the rule of law, and it is a court of law that makes the final decision. So the Deputy Prime Minister has been totally exonerated in a court of law.
My next question is in relation to, and we know that there most likely be appeals, etc. You did say about different people, were named. It has been stated that there's natural justice not being afforded.
Yes.
You know that has come up in the ruling. Issues about that the whole report is declared null and void in its entirety.
Yes, I am.
And also there were some comments by the judge about you being biased as well.
Yes.
What do you have to say to that?
Yeah, under a judicial review operates on the basis that a person seeking it says, I was not afforded natural justice. That is, I was not afforded procedural fairness. They can also add that the judge was biased, which they have said. They can also add the judge took into account irrelevant information and failed to take into account relevant information. So what the allegation or the statement against me by Justice Tuangaringeri really contains all of that the people were not accorded with the principles of natural justice. And basically, natural justice, as I said, is the right of a party to be heard, either orally, either on paper through an affidavit, or through counsel, and also the right to procedural fairness, and that includes what I've just said. Now, I haven't finished reading the 154-page ruling, but I have been advised by colleagues who I respect as to what Justice Tuangaringeri has said. Well, I can only say, as I've said to you previously, Mrs. Mason and I spent 6 months in Fiji. We spent 9 weeks of hearings in the Supreme Court. We had meet and greets. People were entitled to be represented by counsel and their counsel to cross-examine evidence of a party speaking against them. All of that was accorded. So my conscience is, I would say respectfully to Justice Tuangaringeri, I don't agree with you. I am in no doubt that procedural fairness was followed. There was no bias. This is hearsay. I've heard that because I'm a friend of the Prime Minister, Mrs. Mason and I were like a lynch mob. Now, I've always made it clear as a judge, I will not follow friendships. If I find a friend has broken the law, I will state it. So I can really only go back and say to you what I've said from day one. Mrs. Mason and I did the job that we were asked to do. We did it so far as I've been in the law for 51 years. I think I have a reasonable understanding of what a judge should do. I believe it was done, but the people who brought the judicial review, such as the Chief Justice and Miss Mali, they have a different view. They then put that view to the court, and Justice Tuangaringeri believed them. And I, again, will accept that I don't agree with Justice Tuangaringeri's findings, but he was the judge in that. I wasn't. I'm sorry, I cut you off. I think you were going to ask me something.
I was just allowing you to finish off your sentence. Justice Ashton-Lewis, do you still intend to become the Chief Justice of Fiji?
Absolutely. Well, now, that's a silly question, and I'll tell you why. To become the Chief Justice of Fiji, firstly, Justice, you will know one of the recommendations was that Justice Timo be suspended and put before a tribunal of 3 independent judges, like what happened to Justice Kumar. Well, that hasn't happened. The Prime Minister hasn't recommended that. So Fiji has a Chief Justice. There's no need to appoint another one because Justice Timo is legitimately the Chief Justice of Fiji. The Prime Minister has chosen not to follow the recommendations in the Commission of Inquiry report, and so that's where the matter ends. So I have no intention of being the Chief Justice, and I would address that question if I'm asked. Now, that's not going to happen because Justice Timo is not going to be suspended and he is not going to be placed before a tribunal. So he legitimately, legally remains and stays on the bench as Chief Justice of Fiji. And I would have to be, my 3-year appointment as a Supreme Court judge ends on the 3rd of December this year. Well, we're getting close to that. So unless, I repeat, unless the current Chief Justice was suspended and put before a tribunal, and I was asked to come back, I would only be in the position of acting Chief Justice until and unless, like with Justice Kumar, Justice Timo was terminated. So I can only really repeat again, the answer to your question is no. I am not going to become the Chief Justice of Fiji.
Oh, why I asked you the question?
Yes.
My question was, do you still intend to be the Chief Justice of Fiji? Because you were approached twice by Mr. Ramuka, one as the leader of opposition and then as the Prime Minister.
If I was asked again, I would then say to the Prime Minister, I need to think about it. I'm 76 years of age. I've had cancer. They have found a tumor in my bladder, which is to be operated on in the next month to remove it. So 1, if I was asked, 2, if I was renewed for another 3 years, and 3, if I was up to it physically. I'm certainly up to it mentally and juridically. So if those things happened, I would then say, because it would be the Prime Minister who would make that request, I would then say, let me consider it. So I'm not going to ask if that's what you're seeking, Mr. Narayan. I won't be asking to be appointed Chief Justice. And I repeat again, because Fiji has one.
The actual files, the Commission of Inquiry report was forwarded to the police and the Office of the Director of Public Prosecutions.
Yes.
You would know they've come back and they've said there's nothing in it that they can take further in terms of evidence.
Yes, I'm aware of that. And that's
what do you have to say to that?
Well, I can only say I don't agree. You will know a complaint about me was laid to the police, and the Commissioner of Police looked into it and said, we're not going to proceed. And the answer was, because there's not sufficient evidence to bring any action against Justice Ashton-Lewis. Now, that was the police saying it. The DPP could have said, we don't agree, and we're going to lay. Well, it's the Director of Public Prosecutions who lays the indictment, but the police, the DPP, ODPP, chose to believe the police investigation. There's no evidence against the judge. So no, any complaint against him is not amenable to a criminal prosecution. Now, you're
again, they have assessed your report and come up with finding both the police and the DPP.
Yes.
That there's nothing in there to take it further. They've closed it.
Against me, yes.
No, not against you, not against you. What was in the report?
You're not listening to me.
What was in the report? I'm talking about the report. I'm talking about the report, Justice
Well, I'm
Ashton.
not. I'm talking about how that you appear to me that whatever is said on one side, you just believe. Now, I've gone to great lengths with you as a judge to say the battle with any decision maker is, now you might have your view of me, you're entitled to have that. Fiji is a democracy. But everything you've put up to me so far, where there's been a decision opposite mine, I've said to you respectfully, I don't agree with it. I can do that. And then where something has been put up that does support me, I thank you for the courtesy of hearing it, and you'll form your own view. But I repeat again, the fact that Justice Tuingeri, that the police, Nancy Tukusuva, John Rambuku, he came in and gave evidence. Now, we did not form a good opinion as to his frankness, and that's stated, you will have read it, in the Commission of Inquiry report. Now, he's Miss Tukusuva's deputy, and he was, you used the word before, some of the things, he was conflicted. And again, you will have read that in the report. Well, all I can say to you, again, Mr. Narayan, you strike me as, well, I don't think you're biased. You're doing your job. You're an investigative journalist. But look, I put up recommendations. It was for the other people to say, yes, we're going to go forward on that. Some they did, some they didn't. Then it came to the final stage, when a justice of the High Court of Fiji heard all this evidence, had it all, and said, I don't agree with the commissioner, and also made statements about me being biased, not following proper procedural fairness. Now, I can only say to you, as I've said, I respect Justice Tuingeri. He's not sitting on the High Court because he's a dill. Well, I wasn't a High Court judge because I was a dill. It was because I was good. And ultimately, a commissioner of inquiry, and ultimately then a justice of the Supreme Court. One of the hardest things for a judge to do is in judicial meetings when two judges hold different views, and it has to be argued out. So I can only repeat what I've said to you a number of times. I respectfully don't agree with the findings of Justice Tuingeri. Now, we've got to be careful, really, talking about this, because you might be able to show me the truth on this. I understand after he handed down his decision, certain people were saying, we won. Well, that's a bit of a silly thing to say, because as you know, and I know, the Prime Minister is appealing Tuingeri's decision. And I've been advised that he's also taken the view, and if I'm unsuccessful in the Court of Appeal, I'll take it to the Supreme Court. So there's a long way to go, and the Prime Minister is the right party to appeal this. He is the person who established the Commission of Inquiry and recommended to the President.
Thank you. And just this afternoon, the Prime Minister's lawyers have stressed that they maintain the procedural obligations of an independent inquiry, including the affording of natural justice, rests exclusively with the Commissioner conducting a COI, that their client and the President should not act as appellate reviewers of the independent commission's internal procedures. They've also confirmed that they'll argue this matter strongly. They will also take further decisions on what they will be appealing, and those appeals will be done after the determination of cost and damages. And of course, this matter continues. The appeal can only be filed after the cost and damages issues raised. Justice Ashton-Lewis, thank you very much for speaking to us today. We know that you agreed to speak to us. And of course, there's conflicting issues with different points of view, and it is our job to ensure that we get this out for the people based on what has been said, what is being said, the decisions that's been made, and I greatly appreciate your time for speaking to us. Thank you again.
Well, I appreciate your fairness and doing your job, and yes, the people must know about this. So thank you, Mr. Narayan. It's been a pleasure to speak with you. And I know your job is not easy, but in a free society under the rule of law, one of the most important things is independence of the media, the print media, the visual media, that they report both sides. And I commend you for doing that. So thank you.
Thank you. You have a great afternoon.
The same to you. Bye.